Thank you for joining us. My name is Sean Timmons, and I'm the managing partner of our Tully Rinckey PLLC Houston, Texas office. However, as you'll learn during the course of the presentation, I'm only physically present in the office about 2/3 of the time. You have 1/3 of the time. Approximately, I'm on the road advocating for individual members of the military in proceedings throughout the globe, either in administrative separation boards, court martials, or other legal proceedings, just federal court cases for reservists or guard members or other civil litigation matters. So my experience is varied. I've been with the firm for almost 9 years now. I've been in private practice for oh goodness, going on 12 pretty soon, 11 years plus. I've been an attorney for nearly 16 years. I started my legal practice in 2009, right after the financial crash and crisis of 2008. So I've been a military lawyer for the duration of my career, ever since joining the 179th Officer Basic Course at Fort Lee, Virginia, and training over in Charlottesville. So I want to welcome all my colleagues from the 179th who may be joining, or anyone else in my legal career who I've encountered across my worldwide travels. Thank you for listening to this presentation. It's really just a summation of some experience and some good practice pointers I want to identify for individuals who are facing certain predicaments with their military career. So a little bit about my background. I've done a countless number of court martials. I handle several a year, also several civil trials per year in federal court. Occasionally I'll appear in state court. Also, I've had several court martials all the way from inception to full verdict, or an acquittal on the merits. And I handle separation boards pretty much as a day in, day out practice. Think of it like the McDonald's drive-through. A separation board would be one of the main menu items that we serve daily. So I don't want to trivialize the fact that it's a very serious proceeding, but I also want to identify the fact that I handle it routinely. So to me, it's pretty common day-to-day occurrence. So with that, there's a lot of overlap, and we'll talk about that as we go forward. So you can move on to the next slide. That's my introduction, who I am, what I do. And today's presentation is just a very, very quick overview of the administrative separation board process in the United States military. There's a lot of similarities between the Army, Navy, Marine Corps, Coast Guard, and Coast Guard not technically part of the Department of Defense, Department of Homeland Security, but a lot of the terminology is very similar, and the regulations are very, very similar. Same with the Space Force and the Commissioned Corps of the United States Health Service and NOAA and other federal entities that may fall under have these procedural due process rights. So anyway, that's the overview. It's a very generic description of the process. If you have any individual particular questions or concerns about your specific case, you're more than welcome to consult with me privately. I don't want to get into the weeds of anybody's unique facts, because that might break confidentiality concerns, and we don't want to have your public information broadcast on a forum that'll be reproduced throughout social media. We can move on to the next slide. All right, we will not be covering today the process, also known as NJP, non-judicial punishment, Article 15. We will not be covering the court-martial process, which involves getting charged with the crime in the military and being prosecuted by military courts. Nor will I cover administrative reprimands, GOMARs, letters of admonishment, or permanent blemishes in your file. Although they often result in separation board proceedings, I may touch on it just briefly to explain the fact that if you're served with a GOMAR, which is a general officer reprimand, same thing in the Navy, a similar type reprimand, you probably will be facing a separation board legal proceeding in the future. The medical separation board process is a concurrent separation process. Many individuals facing separation for misconduct are also suffering medical ailments that may cause their misconduct. So they're also going through the separation board process for medical evaluation, and that determination on whether someone will be separated medically or administratively is usually made at a very high level, either the commanding general or the admiral, or in officer cases at the secretary level, Secretary of the Air Force, Secretary of the Army has to make a final determination on which process will be binding, either the separation board process with a punitive discharge or the medical separation process with a medical disposition. So to the extent medical separations have any impact, sometimes medical conditions cause individuals to engage in misconduct that results in a separation board proceeding. But that's the extent I want to talk about that today. I'm the presenter here, and we're going to talk some key takeaways. I entitled this initially War Stories, meaning I want this to be described as what I envision maybe 30 years from now as sitting at the VA, going through a history of life and just explaining what I've learned in practice, because that's why it's called the practice of law. There's no perfection in it. You get better at over time. The more law is probably one of the few professions where you actually get better and better at it the more and more you do it. Many people, to generally, there's an age bias in the legal profession towards older counsel because they're more experienced and wiser. And there's a bias against younger counsel who are maybe not as experienced. Most professions the other way around. They want somebody younger and more robust, they think, or more energetic, they think, and that's usually causes our age discrimination cases. And in the legal profession, I find that the more seasoned, the more gray hair, the more wrinkles you have, which I've acquired several, the more deference you're given, and because you get better and better. It's just like lifting weights. The more you do it, the better reps you get at it. And same with legal practice in these cases. The more I do it, the more routine it gets, and the more I've learned and takeaways I can share from that. So I welcome any questions you may have. Feel free to hit me up with any questions you might wish to, find information for. But again, no guarantee I'll be able to answer it to the extent necessary because confidentiality concerns and other issues. Let's move down to the next slide, slide 5. So there's several types of discharges. Many people call me routinely and are concerned about getting a dishonorable discharge or a bad kind discharge and other terminology to get mixed up. Just know that a bad conduct discharge or a dishonorable discharge is not something an administrative separation board can give you. The only way you end up with a bad conduct discharge or a dishonorable discharge is through a conviction by a court martial with full due process rights, a trial, your right to a panel, meaning a jury, your right to full display of evidence, your right to full defense, or your right to access to experts, your right to discovery, all kinds of rights and privileges that you would not be afforded necessarily in an administrative separation board. So a court martial process that results in a punitive discharge as a bad conduct or a worst case scenario dishonorable is not something that any board can give you. However, that being said, there are 3 types of discharges a board can issue. And the worst, as you might imagine, is what's called an other than honorable, OTH. Other than honorable sounds synonymous with dishonorable or bad conduct, but there are legal distinctions. You don't lose all your legal benefits with an OTH. You just lose, say, 90% of them, or that's a rough approximation. A good percentage of them. You retain a few legal rights with an OTH, but very, very few. You don't want an OTH. An OTH, from a civilian employer's perspective, might as well be a dishonorable discharge. They don't know the difference. In fact, when they read other than honorable, they usually read it as, oh, you got a dishonorable discharge. We can't hire you because you're dishonorably disgraced yourself. Therefore, you're not employable. Good luck to you. Goodbye. So you definitely don't want that other than honorable discharge. Other than honorable means that time of service is not credited towards any civilian occupation or any kind of retirement program generally, and it's a real big stain on your record, and generally it's going to cause you harm for the remainder of your life. So avoiding an OTH at all costs is imperative to avoid that permanent blemish on your record you'll need to explain for the duration of your life. A general discharge is considerably better. However, it does show somewhat of a blemish. It's considered under honorable conditions, so it's credible for federal retirement purposes. State programs allow you to buy time into it, especially in Texas and other states like New York. So a general discharge is kind of a mediocre discharge. It's not awful. It's not catastrophic. It's not ideal, but it's certainly not terrible. And you retain most of your legal benefits. You lose access to the post 9/11 GI Bill, maybe the Montgomery GI Bill, the interest rate reduction loan on mortgage applications, which is the IRR program for refinancing your interest rate below market rates. There's a certain few niche benefits you lose with having only a general discharge. However, with a general discharge, you retain between 80 and 90% of your benefits. So if you get a general discharge from the military, you're in pretty good shape. You're not in great shape, but you're okay. You've got credit for the time you performed, and generally your time is considered to have performed to the best of your abilities, although it wasn't the gold standard, which obviously is the honorable discharge. If you get an honorable discharge, you're set for life, meaning when you're old, you'll have access to a VA pension, you'll have access to VA medical care for life, you'll have access to all the benefits the government offers honorably discharged veterans. So you'll have access to the full cafeteria of all available benefits. Many of which benefits people aren't even aware they're eligible for. So if you are an honorable discharge veteran listening to this, I encourage you to talk to your state commission on Veterans Affairs, talk to the VA, consult with an attorney, find out all the benefits you're actually entitled to, and try to take advantage of those different programs. They usually don't advertise the programs, but every year they pass more legislation to increase benefits associated with being an honorable discharge veteran. So definitely want to take advantage of all those different programs. That would be a whole seminar in itself to go over every legal entitlement honorable discharge opens you up to. But for example, in New York City, you can get a reduction in your rent if you're an honorable discharge veteran. All kinds of different available programs depending on which jurisdiction. Obviously, a GI Bill, education benefits, home loan reduction on your interest rates, medical care, access to quality nursing facilities. In fact, many people call me when they hit elder age and they want to upgrade their discharge from Vietnam because they realize had they had an honorable discharge, their access to nursing care would be so much better than the fact they're stuck with Medicare or Medicaid or whatever the state or government funded program is for the elderly. Having an honorable program is the gold standard for anybody looking for elder care when you're much older. So having an honorable discharge by the time you get later in life and you need someone to care for you is imperative. Unless you have family that's well resourced and is going to provide for you, if you're going to rely on the government to help you out in old age, you definitely want that honorable discharge. The VA will make sure any facility you're in or needing care from, it takes care of you very well. My father went through Parkinson's on his last stages of life, and he was 100% VA disabled Vietnam veteran, and the care he received was tremendous. Prior to having his VA rating, though, and documentation, he was stuck in a Medicare funded place, and it was terrible. Went to the VA facility, and it was lights, massive difference. So you absolutely want that honorable discharge, if for nothing other than the fact that when you get old and if you're incapacitated medically, you want the government to take care of you since you provided for the citizens of this country. You want that honorable discharge. And again, in summation, an honorable discharge entitles you to the full range of all benefits possible. An OTH, however, deprives you of almost everything. So between those two extremes, the general, where you get some benefits, but some are taken away. It's case-by-case basis. Don't have enough time in this seminar to go through the differentiation between all three of those. But from a generic perspective, having a general discharge, you'll probably be okay in older age, but you won't be necessarily the gold standard. But avoiding an OTH is the whole purpose of this presentation. So we'll move on to slide 6. All right. This is your right to a separation board. Generally, if you've served enough years in service, you're considered to be vested in the military with continuation, so you're entitled to what's called procedural due process and substantive due process. What that means in English is they can't just paper you out the door. Now they can if you're early in your career, or if you're an entry-level status, you can join the military, and if you don't hit certain length threshold requirements, you can be quote unquote papered out, meaning you're given paperwork and you're out of the military. If you serve at least 6 years though, and you engage in alleged misconduct or you have a performance blemish and they say, lack of better description, you're terrible at your job, you can be separated, but you have to go in front of a board first before they can just throw you out. If you're under 6 years and they want to give you an honorable or a general, they generally can do that with paperwork alone. You have a right to respond to paperwork and say, no, I should be allowed to retain and I should be allowed to continue, but you don't have a right to a formal board to review it. So it's up to command to decide, okay, no, we don't think you're sufficient, therefore you're gone, if you're under 6 years. Once you hit 6 years or more, though, you automatically have a right to a separation board, even if they're trying to say, we'll give you an honorable. If you want to stay to retirement, you can fight the state of retirement through the board process. Now, if you're in even for, say, 9 months and you're hit with misconduct and they want to separate you out with what's called an other than honorable, OTH, then they have to give you a board. And be careful of that because they often try to trick, and I see this in the Marine Corps and I see this in the Navy all the time, and I'll talk about this here in 1 second. They serve you with paperwork saying, hey, you failed the drug test. Here's your paperwork. Take an OTH and sign a board waiver, or we're going to put you in jail. And people get freaked out, scared, and think, oh my goodness, I don't want to go to jail, so I better sign whatever paperwork they give me. And what they end up signing is an OTH board waiver and a agreement basically not to be prosecuted in exchange for taking an other than honorable discharge and forfeiting your right to a board. My advice to you is generally I would never agree for anyone to sign that document. However, your uniformed military counsel who are buried alive with 100 piles of cases and no resources whatsoever, and the government has all the resources imaginable, access to CID, NCIS, FBI, federal marshals, all the investigative agencies in the government's Rolodex, they can make you miserable and they can threaten to put you in jail for the rest of your life. And many times with TDS as your only avenue to fight back, you're completely overwhelmed and you agree to whatever they give you in exchange for being told you're not going to go to jail for the remainder of your life. Usually it's a bluff and they're usually full of nonsense. But that's the kind of strong arm tactics they use to get you to sign documents against your interest. Never sign anything until you have a qualified, capable attorney who's competent review the material. And unfortunately, I've seen this in the Army recently, they're graduating attorneys right out of law school, right into JAG Corps, right out of officer basic course, and throwing them right into trial defense services. Meaning they've been a lawyer for, say, 4 months, and now they're advising people on their legal rights that'll have impact for the remainder of their life. I'm sorry, but if you've been a lawyer for 4 months, you probably aren't the best at what you're going to do. And I certainly can guarantee you, when I was a lawyer for just 4 months, I was nowhere near as capable as I am today. I'm still not 120% of where I'd like to be. You get better every day. But 4 months in, I guarantee my advice would not have been as strong and robust as an experienced attorney who's been doing it for a couple of decades. So, it's very, very what the military is doing is basically giving you, quote, right to counsel by putting somebody in a position to advise you who's 26 years old, who's just graduated law school themselves, is only a couple of years older than members of the military themselves, and literally is deer in the headlights and has no idea what they're doing, and will roll over for the government. So it's kind of a scam. You have an attorney assigned to you, but that attorney is designed to be either structurally incompetent, not that they're actually incompetent. They're given no resources to fight back for you. And if they do fight back for you, their career is over themselves, and they have rent to pay. They have kids to take care of. They're going to do what they got to do to pay their bills, and they're working for the same organization that you're working for. So, again, as a civilian, they can hate me all they want, but guess what? Only the people who are paying for my services are the individual clients. The government's not paying me anything, so I don't have to worry about being, complicit in their scam. Your right to a separation board now is generally vested if you have that set time in service. But 6 years, as long as you don't waive it. In fact, under some regulatory guidance, you may have to affirmatively demand it, but you're entitled to it by law. So make sure if you have more than 6 years and they're trying to separate you, they don't do so without giving you that right to your board. And you may have to raise your volume on that. You may even have to file a complaint with IG. You may have to file an Article 138 complaint. You may have to use the Navy's process called 1150 to file a complaint. You may have to raise a ruckus, you may have to write a congressional even, and demand intervention by your member of Congress. But one way or another, you need to make sure your rights are protected and they don't railroad you out, and you get your right to a board. One thing I will tell people all the time is, just sign these documents, and in a few months after you get out, you'll get an automatic upgrade anyway. No big deal. Everything's fine. I've heard that from barracks lawyers for the last 30 years. That's the most fraudulent statement imaginable. There's no such thing as a, quote, automatic upgrade after leaving the military. That's a myth. That's a fraud. That's a lie. It's repeated pretty much routinely, daily, nonstop. I don't know why, but it's been something that's been around for decades, and it's a myth. There is no such thing as an automatic upgrade. Occasionally, there are laws passed that do require automatic upgrades. So that may be where the confusion starts. When they at one time, military regulations stated, words to the effect, I'm quoting directly from the military regulations, so don't attribute this personally, please. But the regulation said, quote, homosexuality is not compatible with military service. That was in the regulation. When they removed that from the regulation and they changed the law and said, nope, doesn't matter what your sexuality is, you can serve, then Congress passed a law mandating anybody who was separated with a discharge characterization that was below honorable was automatically entitled to an upgrade. But they still had to request it. Sometimes they sua sponte were given it automatically, but generally they require them to even submit a request, even though the law said it has to be upgraded because we changed policies. We no longer kick people out for having sexuality diversity. However, prior to the 1990s, that was generally an automatic other than honorable discharge. And that's what the regulation specifically said in law. That's changed, obviously, in the last 20 years. And now individuals are welcomed with any kind of background in that manner. So if you were separated previously under the don't ask, don't tell, or even the previous policy, which said flat out you can't be a homosexual, you are entitled to an automatic upgrade. That's a unique circumstance. Most individuals who were separated 20, 30, 40 years ago for drugs or other bases are not entitled to an automatic upgrade. If the law changes, you may well be entitled to an automatic upgrade, but you still need to request it. It doesn't happen automatically. So that's my belief and where the source of the myth comes from. But the myth does not apply universally. It only applies in very unique circumstances. An OTH will stigmatize a veteran for their life, meaning you'll walk around with bad paper for the remainder of your life. You don't want that at all costs. And I don't want that for anybody if you can avoid it, unless it's truly deserving. And it's rarely truly deserving. Most people who sign up to join the military, if they're doing a good job and they're putting forth good faith effort, they're good. They're a good person. That's one reason why I love advocating for members of the military versus, say, ordinary civilian criminals. Ordinary civilian criminals, many of them are hardened people who are really bad, awful people who probably belong behind bars. Most of the members of the military are just good people who make a mistake every now and then, but they were willing to sacrifice their life for our freedom. So that to me distinguishes them from the ordinary common criminal. And that's why I fight so hard to protect the rights and benefits you fought so hard to keep and retain. So the reality here is, if you get an OTH, you're in a real hurt. You want to apply for an upgrade. You want to ask for your records to be corrected. You want to even potentially go to federal court and fight and sue to get your discharge modified. That's a whole separate seminar. Here, we're trying to fix the problem before it exists, meaning you're actively serving now, or you're in the reserves, you're in the guard, and you're facing documentation that says we're notifying you that we're going to try to separate you for an OTH. Before it actually is issued, you can fight back the board process, go to the board, and be vindicated, exonerated, and redeemed, and at a minimum get either a general discharge, honorable discharge, or be even potentially retained. So let's move on to the next slide. It's slide number 7. All right. What is an administrative separation board? An ADSEP board is a legal proceeding generally held by 3 officers, sometimes 1 officer, senior in rank to the individual respondent. The respondent is the individual notified of the means to be separated, meaning you're going to sit there at a proceeding and listen to evidence from the government, the recorder, who's a prosecutor, but not called prosecutor, they're the recorder, meaning they're a government attorney advocating for you to be separated. The Navy doesn't even use attorneys. Sometimes they use what's called legal men, who are just individuals appointed to provide evidence for why you should be separated, but they're not actually JAGs. Sometimes they're JAGs, sometimes they're not. So the Navy's a little unique. Sometimes they go to administrative separation board proceedings without even having attorneys as the recorder. There's no requirement the recorder be an attorney, generally speaking. Usually, though, in the Army, Air Force, the recorder is an attorney. Navy, usually they're a JAG, but sometimes they're not. The respondent is the member of the military facing separation. So, for example, Staff Sergeant Smith would be the respondent. The recorder would be me, Captain Timmons. The members would be, Colonel X, Colonel Y, Colonel Z, or Sergeant Major X, Colonel Y, and Staff Sergeant Z, or whatever. As long as they're superior in rank and they meet the requirements, they'll be members of the board. If you're a minority or a female, you generally have a right to request the composition of the board include a minority or female. However, the command can override that request if they show military necessity or no individuals were recently available. So you can be, a minority and have an all-white male board if all they have available are all white men. It's not an automatic you're required to have a composition members of the board who meet minority characteristics or female. However, from an etiquette perspective, ethics perspective, it's ideal to have if you're a female on the board. And if you're a minority, have a member of your minority group on the board. So if you're Muslim, have a Muslim member, or if you're Hispanic, have a Hispanic member, if you're African American, have, you get the point here. But it's not something that's automatic. The military can say, no, they're not reasonably available. We have 3 dentists. They're all old, crusty white men. That's all we have available. That's who's going to be on your board. So you don't really usually get to pick the composition of your board. It's kind of roll the dice. Usually, military installations have a standing list of members identified to sit on these boards, and they usually pick from that standing list. And the board president is someone senior to everybody. And sometimes the board president is conflicted out too, and they have to swap them out. So the board members are fungible and interchangeable, but they generally should be reflective of members of the service, and they shouldn't have a composition of 25 white males. If they have 25 members of the standing board, it should be demographically, equivalent to the population of the installation, ideally speaking. But it's not a requirement per se. There's an issue to raise though, if you feel like there's a problem. You have rights at these proceedings. Your rights include your right to identify witnesses, to have them called to provide testimony, generally telephonic testimony. They don't have to produce them physically and pay for them to travel. At a court martial, if the judge grants you rights to a witness to be physically present at trial, the government generally has to pay for their travel and logistics to physically be there. At a board, that's not necessarily required. You can request it, but they don't have to provide it. What you then would do is call them telephonically or via Zoom or Teams or some other mechanism. If the government calls witnesses to testify against you, your attorney has a right to cross-examine those witnesses, meaning ask questions, undercut their story, refute their allegations. And you have a right to in-person representation, either by a uniformed JAG or by an attorney at your own expense. Now, again, that at your own expense, sometimes they try to game that out and make it really, really expensive for you by jerking you around, by having multiple proceedings, by just making the cost prohibitive. That's not necessarily unlawful, but it is unethical, and we fight back against that as much as possible, trying to keep costs as efficient as manageable and as feasible. But sometimes the government deliberately tries to increase costs for individuals who hire private counsel, specifically to discourage it and to try to move the process along. You have a right to speak at the proceeding. Obviously, you have a affirmative right to testify to defend yourself, but it may be in your best interest to say nothing and rely on the government to meet their burden of proof. In any proceeding, the burden is on the government to establish by a preponderance of the evidence the allegations against you. So you have no affirmative duty to do anything. However, sometimes it's in your best interest to provide testimony on a case-by-case basis, especially in drug cases. Often they want an explanation on, well, we have a drug test, and we have a permissive inference says if there's a test, that means you obviously did something wrong. So if you really are a victim of innocent ingestion or poisoning or a lab failure, you need to explain it. We want to hear why. So often in drug cases, it may be advisable at a board proceeding to testify to explain the source of the contamination, the source of the poisoning, what happened to you, or have at least witnesses testify through your story to explain the source of the poisoning. I was given brownies with marijuana and I didn't know there was marijuana brownies. I thought they were legitimate brownies. I was given gummies. I thought they were candy gummies from the store. I didn't realize they were marijuana gummies from the New Orleans dispensary or whatever your story might happen to be. Same with sexual cases. In sex cases, if you're being accused of sexual misconduct and you provide no testimony, and the only testimony they hear is the victim, well, it's no longer he said versus she said. It's she said versus nothing. And then they may just go with, well, they believe the story they're hearing. You have no defense. They may believe the story they heard. So you may have to tell a counter narrative. Well, actually, she's the one that took my clothes off. I'm the one that was the victim here of engaging in reckless behavior because I went along with what I thought she wanted to do, or whatever your story happens to be. So that actually worked in a few of my boards previously, when the respondent actually provided evidence that said, look, I understand quote unquote victim feels victimized and traumatized by what occurred. But the reality is we were both inebriated and both intoxicated, and I was even more intoxicated than she was, and she was the aggressor towards me. And that she was the aggressor, she was the one on top of me, defense has worked in several of my cases. Ironically speaking, boards, they raise their eyebrows. Oh, okay, well, I can see how it happens, especially if you have evidence to corroborate that with other witnesses. I had witnesses before. Yeah, we saw her kissing all over him. Yep, we saw her touching all over him. We saw her X, Y, and Z. That can speak volumes. If enough people will say, yeah, we saw X, Y, and Z, and you have the story of victimization, they may be more inclined to believe your side of the story. Same with sexual harassment cases. You want people to come and testify and say, well, we don't believe it was sexual harassment because this is not what really happened. What really happened was this. You need evidence to refute the story from the government, and you may need witnesses to testify to corroborate your version of events. Now, the best possible outcome is retention, continue to serve, maybe even get a backdated promotion, because the board makes findings. The findings they make are, did the misconduct as alleged occur? Yes or no? If no, then the case is pretty much over and you're retained automatically. And then you can use that documentation of no to say, look, the investigation that says I did something wrong is corrupted, and it was half-assed. I'm sorry to be so crass here, but it was deficient. It was haphazard. It was sloppy. It was terrible. And here's a full evidentiary board that heard all the evidence, all the materials, and determined I did nothing wrong. Therefore, I should be entitled to remedial relief in the form of a special promotion board, other remediation of my documentation, and maybe given a backdated promotion and my career fully, made whole. I have had that happen a few times, and the process that starts that off is the board saying, no, misconduct did not occur. An individual respondent here is innocent completely after our full review of the evidence. Assuming it does not happen, they will say then, okay, we do find evidence sufficient to believe misconduct occurred. That doesn't mean you're separated. They still have to answer the next question, which is, should this individual be retained or should they be separated? If they should be retained, then case is over, even though they have a blemish in their record. If it says separated, then they move on to the next question, which is question 3. Okay, what characterization of service should be given? Honorable, general, or other than honorable? And here, if they find misconduct and they believe you should be separated, they usually go with either a general or other than honorable. However, this is where advocacy can make a significant difference, because sometimes your record is so meritorious, and the regulation says this specifically in the language. If your record is otherwise so meritorious that any separation should be nothing less than honorable, that's what the board should give you. So if you've saved lives after a terrorist attack, I had this exact case. I had a airman who was involved in an act of valor, significant valor, had members of another country's government write letters to the commanding general saying how wonderful he was saving lives and how his actions and heroics saved people's lives, even though he did something wrong later in his career. Because he was so heroic in those events, as we documented to the board said, you know what, we're going to give you an honorable discharge, even though later you did a bunch of things we don't agree with. You got an honorable because we were able to establish a very, very strong documented history of noble, faithful service that was so distinguished, anything less than honorable would have been an injustice. Absent that scenario, you're probably going to get a general discharge or an honorable discharge. And a general discharge, depending on how bad the blemishes are in your record and how bad the alleged serious misconduct is and how culpable someone might be, a general discharge is sometimes a good outcome. And sometimes it's a litigated outcome where that's the best possible disposition you're going to get, is meaning you're facing 20 allegations, and even if you get someone cut out, if the evidence is overwhelming, the best you may end up getting is a general discharge, which still means your credit for your service, still means you may have ultimate retirement eligibility. It still means towards future service. There's still a lot of options available to you with a general discharge. There's also back doors into the guard with general discharge. You continue to serve, maybe you get mobilized back in active duty. But with the OTH, you lose all your benefits, and life is really miserable after that. So you want to get a general discharge at a minimum, and it really depends on a case-by-case basis how serious the allegations are against you and how strong the evidence from the government is from the government's point of view, and whether or not the board believes the government's evidence or not. And often, sadly, it depends on the venue. Formerly Fort Bragg, now Fort Liberty, formerly Fort Hood, now Fort Cavazos. They're the worst Army installations when it comes to adjudicating separation boards for misconduct, meaning they generally are composed of line officers who, in my opinion, and this is only my opinion, so I apologize if it offends anybody, but they generally don't think as thoroughly as individuals in other legal proceedings, in other cases where they're a little more open-minded. They're generally very close-minded and very, they're combat officers focused on a mission of fighting a war. They're not really into legal theories and having an open mind about behavior, whether it was good or bad. They're just very, very, very harsh. And I had a separation board at Fort Bragg, now Fort Liberty, where the officers literally wanted to like physically harm me. I felt like the separation board president wanted to choke me out and probably murder me at the proceeding. That's how vicious and hostile the venue was. I was literally defending my client, explaining that, look, I understand he was absent from his post. I understand he was caught with a civilian downrange doing something he wasn't supposed to do. However, this is our defense. And as I started saying our defense, they literally physically wanted to like stop me from talking. It was so shocking. I was actually in fear of my life for a moment. Like seriously, I'm being legitimately serious. Their manners were so aggressive. They were so hostile. The lawyer had to tell them, hey, we got to keep this professional. That was their lawyer's perspective to me from the board. From the board. That's how hostile some of these the boards can be. How vicious and adversarial the proceedings can be. Other times they're super soft. I went to a board proceeding at West Point, and my client was accused of horribly salacious, terrible misconduct. And he was guilty of horrible, salacious, terrible misconduct. Yet they were two dentists and a surgeon. And they gave him an honorable separation and allowed him to retire, even though his misconduct was something that most people would go to jail for. So it's really hit or miss when it comes to these boards. If you have a board full of softball dentists, you might be in great shape no matter how bad the facts are. And if you have a board full of line officer infantrymen who want to charge the hill and murder the enemy in cold blood, no matter what you say, there may be nothing you can do. So it's really why the lawyer's advocacy is important to protect your legal rights to appeal too, because the record is producible to higher level authorities, even if the board themselves is completely, unwilling to look at any evidence or review any materials. Preserving errors and preserving issues for a higher level review is critical during the board process. So you don't get from later reviews saying, well, you waived your argument and you didn't raise those issues, so nothing we can do about it. You should have brought it up sooner. Bringing up all the evidence in your favor at the board protects your rights for a higher level review, and is critical. Another reason why advocacy is significantly important. If you have a trial defense attorney and they're intimidated by these senior colonels who want to choke out the attorney, they may not be willing to put on the record material that'll protect you in the long run. They might just be willing to sit there and be, okay, let's sit over as fast as possible. And if you have an attorney who says they want to sit there and get it over as fast as possible, they're not going to protect your legal rights to the extent necessary. And that's concerning and sad, but it happens all too frequently. And frankly, it's because they're intimidated, and it's sad. So don't let your lawyer be intimidated. One thing I'll tell you is I don't get intimidated by any of this, and I kind of laugh it off now. And the more angry they get at me, almost reverse internally smile, because it shows advocacy is working and it's effective. So kind of reverse the logic there. But it takes a lot of experience to get to that point where you kind of blow off the hostility you face in these venues. So moving on to the next slide 8, some additional considerations. Now, just because a service member is being medically separated or pending retirement or is actually close to retirement and is in, quote, sanctuary status, does not mean an administrative separation process is not going to happen or it's impossible. Some people think, okay, I get to 18 years and I'm good, I'm gold. Well, no, they can still separate you. This requires a higher level of review. It requires, like in the Army's perspective, the Secretary of the Army to agree to initiate the process and put you in front of the separation board process. I've had members of the Navy separated 19 years, 11 months, 20 days. And we had to go to federal court to ask for injunctive relief to drag them out to retirement eligibility. And federal courts are reluctant to get involved in those scenarios, but it is possible. So we have to pull out the procedural trick book and throw a bunch of Hail Marys in federal court to try to save somebody's career in that scenario. But it is possible. It is possible to be separated one day before the 20-year eligibility for retirement. And if it happens, then you didn't meet the 20-year requirement. So be mindful of that. Individuals can still be held accountable even if their time is serious. And I often see the senior officer cases. They get to year 16, year 17, year 18, year 19, and they start getting a little reckless. And that's unfortunate, but be mindful that you want to be on your best behavior, especially because from an officer perspective, even if you do retire, you hit the 20-year eligibility, they can demote you in retirement. So if you were a colonel, they can cut you down to like a major and say, well, you didn't serve honorably as a lieutenant colonel or a full board colonel. We're going to reduce you down to major. And you're talking about a reduction in your benefits of hundreds of thousands of dollars over the course of your lifetime. So that could be catastrophic to your long-term retirement planning. And it's humiliating too. I mean, you serve years as a colonel, now you're going to be retired as a major permanently, and you can't hold yourself out as your highest rank, unlike some individuals who try to do. You have to hold yourself out, legally speaking, as the highest rank the rank you were when you retired. So it's ideally, whatever rank you retire at is the rank you should tell people you have and hold when you are retired, and not, you shouldn't be General Smith when you and then be busted down to, Lieutenant Smith and tell everybody, hey, I'm General Smith. No, if you're a lieutenant in your retirement purposes because of a grade determination board through an admin separation process proceeding, then you have to hold yourself out as the rank you retired at. That's the law on that. Anyway, additionally, I've had lots of examples of success stories with individuals who were facing all kinds of terrible situations. But let's talk about one example here. Navy active duty E4, several instances of misconduct, initial issues through active leadership, the improvement, service members improves, but then they pop THC again, command administers non-judicial punishment, start recommended for separation. You have several rights here, right to a board, right to fight back, a right to demand full due process, and a right to try to be retained and have tell your side of the story. Now, I talked about this in the initial opening. If you're facing separation board for you're facing medical separation, you may also have engaged in some misconduct concurrent with your medical issues. A lot of manifestations of PTSD are, according to DSM-5, is what's called self-destructive behavior. So individuals who have severe PTSD may engage in self-destructive activity that's detrimental and out of character, and that often manifests itself in actions that are unlawful or very imprudent. Obviously, you get all the medical care you can, get the proper treatment and the medical care you're entitled to under the law, but also know that you want to be able to have an advocate tell your side of the story to explain, no, this was out of character because my normal character prior to the trauma I experienced was a good member of the military, and I should be given a medical separation and retained these board proceedings here so I can be given the proper medical separation I'm entitled to. Let's move on to the next slide 9, some applicable service regulations. Okay, so each branch of service has their own regulatory soup on how they process these separations. This is obviously, we could have 3 hours of a course just going through the Army regulations, or just going to the Navy, just going to the Air Force, and getting into the weeds of the technical nuances of it all. I put the slide here for reference points so you can study it independently. There is AR 635-200 for enlisted, and then there's officer separation regulations, and there's also the medical regulation, which, if you fall below medical retention standards, you can face a medical separation board process to be separated. Same with the militaryman, same with the Air Force, Space Force, same with the Coast Guard. They all say, in different phraseology, basically the same stuff. There's some overlap, there's some changes in wording, but generally it all gives you a right to a board, and generally the service has a right to separate you if your performance is deficient or you engage in what they consider misconduct. And misconduct in the military is not like the civilian world where it's actually a crime. Misconduct in the military can be something as simple as not showing up to work on time. If you work at Burger King or McDonald's and you don't show up to work on time, they generally don't, try to permanently blemish your life with negative documentation. They just fire you and you're gone. In the military, though, if you get an OTH discharge, you carry that with you for the rest of your life. And that can be catastrophic. And it may just be simply because you were late to work a few times. I'm not exaggerating. Being late to work, and you can be prosecuted for dereliction, conduct unbecoming, service discrediting behavior, malingering. I can name 5 or 6 overlapping charges basically on a couple of facts of you were 5 minutes late to work 3 days in a row. It's a pattern of misconduct, it's a pattern of malingering, pattern of service discrediting behavior. Now, usually they don't target somebody that aggressively, but it does happen on a case-by-case basis. So the military holds members of the military to a very high standard of performance. Not everybody's able to meet that high standard, especially over time. They get burned out, they get exhausted, they get medically impaired. They may not be able to meet that standard continuously. That's why you want an advocate to help fight back for you and show why you should be given mercy and a second chance, or why the allegation against you didn't happen the way the government is alleging. It's critical to work with an attorney who knows the culture of the military, knows the regulation, knows the culture enough to know that at Fort Liberty, formerly Fort Bragg, it's a very hardcore military culture. And you have to speak the lingo when you advocate at that installation. Otherwise, you're going to get bulldozed over and buried alive. Also, someone who's familiar with the customs and courtesies of the Navy and the other branches of service. If you have an attorney who's handling divorces and they help you out with your military case, they're probably going to have no understanding whatsoever of the military process. I've helped lots of family law attorneys who have children in the military, and they often are confused about our advocacy strategy because they want to either do a certain strategy that works in the civilian courts in their location, and in the military, it's a whole different language. And I've had plenty of times other attorneys have called me, quote unquote, a moron or an idiot for not doing it the way they wanted to do it. And then later apologize to me after their child got an honorable discharge or retained, because they realized our strategy was critical for the language of the military. And when they realized that later, oh, I'm so sorry I called you an idiot. I realize now what you were doing was exactly what the military wanted you to do, and it worked out beautifully, because now our son John has been retained and he's got an honorable discharge and his rights and privileges are protected. And had we continued doing what we were doing as attorneys from our family law background, we would have probably caused our child to be sent to jail. So definitely need an attorney who can speak the military language, somebody who's a veteran. And frankly, not that many lawyers are veterans. Most lawyers are too snobbish to have ever served in the military. That's just I'm sorry to insult anybody, but the reality is most lawyers come from backgrounds that don't amend itself to military service. And that's unfortunate, but that's the reality. And for example, let me go real quick into an example of how I can explain that. I went to a conference in Puerto Rico about a year and a half ago, and I asked a Fortune 500 company general counsel, "Sir, what does the USERA compliance protocol look like for your company?" And he looks at me and he squints his eyes and he shakes his head and he goes, USERA. Oh yeah. We've lowered everybody's interest rate." And I just flabbergasted. Sir, that's the SCRA. That's the Service Members Civil Relief Act, where you lower credit card interest rates. What does your employment USERA compliance protocol look like? And he had no answer whatsoever. He didn't know what USERA was. USERA is the Uniform Service Members Employment Reform Rights Act. Every veteran is entitled to legal protections under USERA. This attorney who graduated from Harvard had no idea about USERA whatsoever, nor did he realize his hundreds of thousands of employees, thousands of whom are veterans, were entitled to legal protections under USERA. And why did he have no clue about this law whatsoever? Because he doesn't know anybody in the military. He never served. No family served. No members of the military whatsoever. The only thing he knows about the military is probably when he attends a suite at the football game that somebody gets the national anthem. And that's about it. So if you don't know the language of the military, you're going to be aloof and clueless when it comes to advocating for those in the service. So that's why it's critical to have somebody on your side who is a veteran themselves or are currently on active duty themselves who can fight for you. So let's move on to the next slide. Significant legal victories. Too many to talk to about, but I want to say one in particular. I had a scenario where my client literally wrote down every element of the offense. And I'm going to analogize this, so it's not an exact analogy, but I protect the interest. Imagine you're facing accusations of arson, and you're accused of arson, and you say words to the effect of, "I'm really sorry, I deliberately burned your dwelling of yours," meaning another, intentionally, deliberately, with malice aforethought, to burn and destroy permanently. And I did so laughing, and I was happy to see it happen, but I'm really sorry it occurred. You just admitted to every element of arson. The malicious burning of a dwelling of another with the intent to destroy permanently. That's the elements of arson. Imagine you wrote all that out and you admitted to all of that. We still got the individual retained, even though they admitted to everything. Why? Because you tell a different version of events, and you turn the admission against interest on itself, and you explain it with a different context. That's, again, why advocacy is so important. And I've had plenty of cases, and my assistants can vouch for this, over the years where we thought the odds were stacked against us and there was no chance whatsoever a positive outcome, yet we had a really good outcome because, again, we tell our story for our client from the best light possible and try to spin the facts on their head and undercut the government's narrative. So I've been to installations across Germany and England, all over the United States, Alaska, Hawaii, and every one of these locations I've gone. I follow a very standard formula: drama, scandal, corruption, redemption. There's drama that occurs. The government's corrupt in the way they attack it excessively. The scandal is, being undone here, and we write the story of redemption. So all the other stuff I mentioned, what are you hiring me to do, or my team to do, or any of our members of anybody on your side to do? Is to write your redemptive story, because the government's going to believe you did whatever they're accusing you of, until you go on offense and undercut it by telling your version of events with good character letters, good soldier packet, good seller packet, and a good presentation of your version of events and your story. But who you have tell your story is critical. And I've got multiple examples of times previously where that was critical, and telling our version of events was ideal. The command is also more inclined to negotiate if they know their case is weak. How do they get to know their case is weak? Your attorney can convince their attorney, hey, this case is garbage, this is why. And once they realize the case is garbage, the witnesses are flakes, they're not credible, the story has a lot of holes in it, the allegations don't merit the activity they're trying to do to you, then they may negotiate an honorable discharge, and they may, you may not even have to do a board at all. So let's move on to the last slide here in summary. It's been a privilege to speak to everybody today. I really appreciate the opportunity for them to listen to me. I apologize for some, rambling occasionally. I do get fired about these cases. Remember, it's vitally important to protect your rights. That's the one theme I want to emphasize here. Never, and I do mean never, volunteer information to investigators. No matter how many ducks they give you, no matter what BS story they tell you, remember, their regulatory guidance specifically permits them to lie to you. Army Criminal Investigation Division, CID, is authorized by law to lie to you, to elicit information that's against your interest. Meaning they tell you whatever nonsense they want. So you cooperate with them and undercut yourself and prove the case for them. So many times the government has absolutely nothing until they get it from the accused, so they get it from the respondent, so they get it from you themselves. Oh, you were in the same hotel room, great, and you did buy her a drink, awesome, okay, and you certainly were, and that was you who purchased the meal, good, and you took her clothes off, great, and you undressed yourself too, okay, voluntarily, great, and you saw her drink alcohol, great, okay, great, thank you so much, thanks for telling your story. We'll be in touch. You just admitted to everything. They had nothing. They didn't know you even knew this person previous to your conversation with them. Never talk under any conditions, unless your attorney advises otherwise, because maybe you have an alibi defense. Maybe you can go in and show, look, I'm accused of bank robbery in Washington, D.C. on October 31st, 2023. But I can show October 31st, 2023, I was in Tokyo, Japan. Because here's my proof. Here's my hotel receipt. Here's the video surveillance footage from the hotel where I was at. There's no possible way I went from Tokyo to DC and robbed the bank when I was in Japan. And if that's your defense, maybe talking to show your alibi is in your best interest. But absent unusual circumstances, providing information to the government investigators is never a good idea, because all it does is help them, again, match up the facts they didn't know. They may not have known you even knew the person who's accusing you. When you go and admit, oh yeah, I took her on a date, you just corroborated the story. And then they're going to use everything you say as a lie, and whatever the quote victim stated as the truth and gospel. So don't provide information. Don't waive your rights. Don't let your rights fall through the cracks. Fight back. Remember your benefits, and literally millions of dollars in lifetime benefits on the line over accusations that may not be legitimate whatsoever. Fight back, and fight back hard, and hire counsel who will do that for you. If you want to have a discussion with us, we move on to the next slide. Slide 12. You're more than welcome to set an appointment, speak with me. You can call 832-241-5888 and book a consult. Everybody has to book a consult. Unfortunately, I get calls probably 10 times a day. Hey, I want to ask you just one question. I can't do that. Why? Because I have to make sure everybody gets screened for conflicts. Because if I'm representing somebody already who you're calling about, I may not be ethically allowed to give you advice if I already represent the person who's accusing you, or vice versa. Everybody has to be screened for conflicts checks. That's why we have to go through a screening process. Once you're screened and an appointment is booked, then you can ask me whatever you'd like in a privileged, confidential communication for the duration up to 1 hour, and we can go over everything possible. But if there's a conflict, then we cannot schedule that appointment. And ethically, I have to do that. I can't take random cold calls and answer random questions, because by the state ethics rules, I have to make sure my staff vets you out to make sure there's no conflict. And if there is a conflict, unfortunately, you'll have to ask somebody else and talk to another attorney. Just remember a few key takeaways. Never talk to the investigators, no matter what they tell you. And remember, they're allowed to lie to you. So don't believe anything they say. Even if they're telling you, stuff that's obviously true, be skeptical, because again, they're trying to elicit information and admissions against interest. And anything you say will be used against you. Not may or could. It absolutely will. And they'll look at it in the most negative light possible. So that's the biggest takeaway. I've saved more lives than I can possibly remember by just having that one basic piece of advice, by not talking. That's the one thing the government wants you to do more than anything, is to come in and blab away so they can use everything you say to build their case against you. And, just remember, I don't know anybody who's free from, fault. Everybody has made mistakes. It's really about going forward in life and trying to build the best possible life you can, knowing we're all individuals who have faults. And some of us have grave faults. Some of us are just, not the best person possible. But members of the military who've agreed to sacrifice their life, who've literally agreed with the understanding that they can be ordered to die. I mean, legally speaking, the president can order you into battle to charge a hill with knowledge you're going to die in that battle. And in fact, in the Civil War, during the Battle of Cold Harbor, I remember one of my professors in college talked to us about this. Right before they went into battle, members of the Union Army wrote in their Bible specifically the words, "I died today." Knowing they were about to die, they still charged the hill at Cold Harbor, knowing they were going to be gunned down. And they were gunned down. 7,000 men died in the Battle of Cold Harbor, attacking the fortified Confederate positions. That's the honor that you serve with. That's the history and legacy of our country, and that's something we should all be proud of. That people have signed up knowing they're going to die, and have literally sacrificed themselves so we can enjoy the freedoms and prosperity we have today. So for everybody who's ever served, knowing that could be just like those men in Cold Harbor who were called on to die for the greater good, thank you, because that's something any one of us could have been called to do, is pay the ultimate sacrifice. And the fact that you were willing to do that for some measly compensation is quite commendable. And when it is measly when you factor in the fact that you may die. So thank you for being here today, everyone. And feel free to look me up, or if you have any questions or follow on, happy to answer any questions you might have. And I get a little fired up over this because, again, that's my job, is to be an advocate and to fight for those who fight for us. Thank you.
I just want to thank everybody again for joining today's webinar, and thank you, Sean, for presenting. Today's webinar was recorded, and a copy will be sent to all attendees later this week. I hope everyone